Perfect. Thank you for that, Henry. Hi, good afternoon, everyone, and welcome for those of you who are here in person and those of you watching a recording of this presentation later. My name is Connor Smith from Martin Law PLLC. I do just want to clear up one custodial issue. I apologize for Mr. Martin not being here today due to some unforeseen circumstances, but I'm very, very happy to be joined by both Henry and Hillary from HWG Law, which has been practicing in the DC area in technology regulation, telecom law, trial and appellate litigation, legal and government ethics, energy, national security, and privacy law since 1998. They are both absolutely fantastic experts in their field, both in legal ethics and in corporate transactions. So without further ado, I'm going to pass it along to Henry, who is going to present a fantastic presentation, which is some unforeseen alliteration. I apologize, but I'm going to make him the host now, and we are going to go ahead and get started. Thank you so much for being here again.
Great. Thank you, Connor. And hello, everyone. My name is Henry Shi. I'm a partner at HWG. As Connor said, I'm also joined by one of my partners, Hillary Gerzoy, and I am in the communications and corporate practice here. And what we thought we would do here today is give a brief, sort of intended for non-lawyer audiences, a presentation on some common issues, legal issues we see in mergers and acquisitions and buying and selling businesses. The intent really is for folks who may have started their own small business or medium-sized business and who are looking to exit or who are looking to move on, or for people who are looking to expand their business and buy something, looking for opportunities to buy a business or a part of a business. And so the scope here really is for more for the smaller businesses who may not have the resources or the need for an entire army of lawyers to go in and look at every issue. And the hope is that knowing what the issues are, being able to spot them, will actually help the buyers and sellers identify where they may need specialized help and where they may need to put their resources into accountants or lawyers or other specialists who can help them. So, three areas that I think would be helpful to cover just in the agenda here. These are basically three phases of really any deal that you'll encounter when you're looking to buy or sell a business, and broken roughly down into preparation. So everything you do before you get into the negotiations of buying and selling the business. Deal structure, which will cover all of the things that you do to get the documents signed, to have a deal, and then how to get that deal to close. And then lastly, closing and after, which is all the stuff that you do at closing, and then importantly, some important things to think about after a deal is closed. Even though it seems like it's been over and done, there are some issues that can sneak up on people, and just we want to be aware of them and be prepared on how to deal with them. So, starting off, preparation, preliminary documents. So this is really the first thing that you should be thinking about, and you want to make sure you get right when if you're a seller, when you found somebody who's interested in buying your business, or when you're a buyer and you've identified a potential target who's interested in talking about whether to do a deal. And right off the bat, I think timing-wise, the first thing and a mistake that people make is not having a non-disclosure agreement or confidentiality agreement at the right time. Right. And the importance of this, I think, is relatively obvious and self-explanatory. When you start talking about, buying a business or selling your business, particularly from the seller's perspective, you will be giving up a lot of very important, sensitive, competitively sensitive commercial information about your business. That just has to happen for any buyer to seriously consider doing a deal. And if you don't have an NDA in place, then that information, if you're giving it to somebody who, in the context that we're talking about, we're sort of thinking about small businesses being bought and sold. Oftentimes, that's going to be a competitor or a potential competitor. And so, if you don't have an agreement in place, an enforceable non-disclosure agreement in place, then the buyer, if the deal doesn't happen, is free to use information that you are providing to them, and that can come back and hurt you. From the buyer's perspective, you typically would be giving away less information in the context of a discussion, but the seller will want to know things about you as well in terms of your ability to close the deal, your ability to finance it. And in some cases, if the discussion, which we see often in our practice, where if you have a founder of a business who's looking to sell, the founder may stay on for a period of time after the transaction closes. And so the seller will want to know information about the buyer. And likewise, if you don't have an NDA in place, then the information that you're exchanging, you risk having that information be misused by the other person. So it's very, very important to have an NDA in place as soon as you start talking about, as soon as you're about to exchange information that isn't public, that couldn't be known by people just looking up, just being aware of the industry and knowing generally about your business. So that's the first thing, is having an NDA in place. Typically, for transactions that are a little bit complicated, where you have an existing business that there may be some period of time where you can't just say oh, I'm ready to buy, I'm ready to sell. There will be a time for negotiating the actual documents. In that case, you may want to have some kind of exchange of information, exchange of terms, to make sure that there's even a deal to be had. Sometimes these are called term sheets, sometimes these are called letters of intent, or memorandum of intent. There are various names that people use, but it's basically a preliminary document to sort of scope out and make sure that the parties agree on just the basic commercial components of the deal, what the purchase price is, whether if you're the seller and the founder, whether you're going to be staying on afterwards, those kinds of terms. And some mistakes that we often see people make here, I think the 3 points that you see on the slide are oftentimes people don't have an exclusivity piece in the letter of intent. And exclusivity here means having a period of time during which the seller is basically giving the potential buyer the exclusive right to negotiate, right? So the seller says, for a period of 30 days, 60 days, however long, I'm not going to shop my business around to other potential buyers. If I get an unsolicited request, I'm not going to deal with them until this period runs out. And typically we see this as a benefit to the buyer, right? Because the buyer then has some time to make sure to not have this deal be taken out from underneath them. It's seen as a benefit to the buyer. However, and something that the seller may not want to give. However, one point that we see is that this oftentimes is beneficial for the seller as well, and sellers may not think about that as a benefit to them. Importantly, having exclusivity in place gives the buyer some peace of mind, right? Because the buyer knows I have 30 days, I have 60 days, however long, to get the deal signed up. And so it allows more time for the seller to negotiate the terms that they want. And so oftentimes exclusivity can be beneficial to both parties. And we point that out here as just a reminder that this is something to think about when you're approaching a deal. Secondly, and this is very important as a legal point, is to be careful, whatever document you sign, whether it's a letter of intent, whether it's a term sheet, to be very careful about which provisions you make enforceable. Enforceable is a contractual matter in that document. Typically, what we see in a term sheet is that the business terms, right, what the price is, what the closing conditions are, all of those things are not enforceable, meaning the parties are putting together this document and agreeing to it and maybe signing it, but we don't want, but we're saying we want to be able to negotiate what's called the definitive agreements for this transaction. And we reserve the right to change these terms and to make modifications to them when we sign this deal. And so those provisions are not enforceable, right? If I sign a term sheet that says I'm going to buy this business for $10 million, subject to signing a definitive agreement that both parties can agree on. So those terms we don't want to be enforceable. Neither side really wants to be enforceable. But there are things that we do want to be enforceable, right? Importantly, we want the exclusivity to be enforceable, mostly if you're the buyer. But there may be other provisions that we want to clarify upfront that we also want to be enforceable, such as the term sheet or the letter of intent may also include separate or additional non-disclosure provisions or confidentiality provisions. We'll want those to be enforceable. There may be cost shifting. Who's going to pay for the accountants? Who's going to pay for the lawyers? Who's going to pay for the appraisers? We'll want those things to be enforceable if the parties agree. So for a term sheet, even if you think about it as a non-binding term sheet, there may be provisions in there that you do want to be enforceable. And so being clear about those and having agreement about those is important. And the last point to make here, I've labeled this as timing. It really is to think about, what you really need to have in a term sheet, right? Don't spend too much time trying to negotiate specific provisions, detailed provisions in a term sheet, because what's going to end up happening is you're going to spend a lot of time trying to hash out those terms. It will be a non-binding term sheet, and then once you spend all that time and all that money negotiating those, when you turn to the definitive agreement, the other side may want to rehash those out again, right? So you'll be duplicating your work in a sense. The point of a term sheet of a letter of intent is to really make sure that there's a deal to be had. Get the key terms right, make sure you know what is and isn't enforceable, and then move on to the definitive documentation. Second part of what we're calling preparation here, this is due diligence. This is really, really important, and some of the points here will come up later on in the presentation as well, in terms of things for buyers and sellers to think about at a relatively early stage in the deal negotiations. So start off looking at some things that we often see sellers get wrong or make a mistake. We're just not have an appreciation if you're, for sellers who are, again, founders, who are, small or medium businesses, who, nobody starts a business thinking about how much they want to do the paperwork or how much they want to do the filing. But these things are really important. So the key point we want to make here for sellers is you want to make sure you have your documents in order, because when you have a buyer come in, they're going to want to know everything about your business if they're going to be putting their money, their investment on the line to buy the business that you have. And again, in a lot of cases, to continue to work with the founder even after the deal closes. So the 2 points, that I want to make here is the first thing is if you're the seller, you really need to have a very clear understanding and to be transparent about the potential liabilities that come with your business, right? If there's an ex-employee who may have a claim against your business, if there are, tax liabilities from the past, if there are disputes with vendors and contractors from the past, all of these liabilities you're going to have special knowledge of, especially if they're not things where you have an open lawsuit, right? If these are just things that people have threatened, or if there's some history in the business where there's a potential liability, you need to have a very, very comprehensive understanding what those risks are, so that you can explain it to the buyer in the course of diligence in response to their questions. And the reason for that is that, the buyer will find out about a lot of this stuff, right? Either doing diligence or if it's a problem that comes up after they've bought the business. And the last thing you want is to have a dispute, several months, several years down the line, where all of a sudden this liability comes up and the buyer is unhappy, the seller is unhappy. It becomes very expensive at that point to even figure out what's going on, right? Because time will have passed, information will be stale, and the costs of resolving those issues will be higher the more you defer them. And so it's important to have, if you're the seller, to know what those potential liabilities are, be upfront about it, talk about it constructively with the buyer, because more often than not, there are ways to solve for that in terms of allocating risk, figuring out how to price those liabilities in, figuring out ways of maybe remediating some of these issues before closing so that you get ahead of this problem and really address it before it turns into a dispute. Because when something becomes a dispute, then when you start to fight about it, it gets really, really expensive, and it's just distracting, and it's not what you want from from the buyer side, certainly, or either from the seller side. The second point here under having your documents in order as the seller, um, fairly self-explanatory. Really have all of the information about your business in a way that's easy for you to present to the buyer and their advisors so that they can review them, right? So all of your important contracts, your capitalization table, who your owners are, who your investors are, who your lenders are. If you are operating in a space that has a lot of business licenses, government licenses, having all of that paperwork in order, all of your tax filings, all of your government reports, making sure that's all in a place that's in an organized way that the buyer can very quickly do the diligence they need to do so that they can be in a position to sign the agreement and move forward with the transaction. What you don't want to have is to, as the seller, is to have to go and try to dig stuff up in response to questions that you get from the buyer. You really should anticipate, you know, most of the things that the buyer is going to be asking, and they're pretty typical questions, right? Depending on the industry that you operate in, and the line of work that you are, the questions that an experienced buyer or well-advised buyer, the questions they're going to have are going to be, um, you should be able to know most of them ahead of time. And so you should be able to prepare to have the responsive documents in place ahead of time. For the buyers, I think the 2 points here are, obviously do the diligence, but an important point is to have your specialists lined up beforehand, right? So you want to, if hopefully you should be familiar with the industry that the seller is operating in. And so if you need to have, regulatory lawyers or accountants, or if you need to have, appraisers, or if you need to have people who are intellectual property experts, have them lined up beforehand. You don't want to be caught in a situation where an issue comes up and then you have to go out and try to find somebody to advise you on this. And the second point, which is sort of the counterpoint of knowing what your liabilities are as the seller, when you're the buyer, is to be open to thinking creatively about how to address them. If you find something in diligence that's a potential issue, there are ways to solve for that in the documentation, rather than just say, oh, there's a problem, the deal is off. Be open to thinking about creative ways of doing that. Okay, moving on to deal documentation. So this is sort of the second part of the three phases that we started with. So this is the part of actually doing the negotiation, actually papering the transaction, figuring out how you're going to get from, here's a deal we want to do to actually closing the deal. And the first point here is to think about the structure of the deal. This is more of a legal point, but there are different ways of structuring a sale of a business, and which structure makes the most sense will be situation specific. Oftentimes it has to do with tax, but it can be driven by other things, such as, are you selling, just part of your business? Are you selling, is the business mostly consisted of, physical assets or hard assets? Or is it mostly, goodwill? And is it mostly the skills of the people who are running the business? Depending on what the situation calls for, you may want to have a different legal structure for affecting the transaction. And again, because it's so situation specific, the point that I want to emphasize here is, for if you're the seller, right? If you're dealing with an experienced buyer, they may have a standard form that they use. That they just have for their transactions, but your transaction may be different. Your business may be a little bit different. Your needs as the seller may be different. So you don't necessarily want to use sort of the standard documentation and the paperwork that the seller has. From the buyer's perspective, be flexible, be open to thinking about the specific situation and what it calls for, and not just rely on your existing standard form. But try not to overcomplicate things, right? You don't want to spend too much time on deal structure, especially if it's from a value perspective, if it's a smaller transaction. This part, the work here can get expensive, and so it's important to understand the business to figure out what's the most appropriate structure. All right. Deal documentation. Once you've negotiated the agreements, um, once you're in the process of doing that, there are going to be a million different issues that you'll have to work through in the agreement, and it can get complicated. And again, what particular issues arise will depend on the business and the specifics of the deal. But the 2 points that I want to make here that come up often and that we see a lot of times with smaller businesses who are sort of founder-led and who are not doing this all the time, and that oftentimes people don't think about until later on in the process, and then it ends up slowing things down, or at worst, it ends up blowing up the deal. The first is third-party approvals. And this is something that oftentimes people don't think about, because you think about a negotiation as between just the buyer and the seller, right? But oftentimes there are third parties that have interests in the deal, and they may have contractual rights to consent to your deal, to approve the deal, or otherwise affect, whether this happens. Um, Typically, the most common types of third-party consents that we encounter, depending on the type of business, if you're in a regulated business, you need government approvals. Depending on the kind of customers you have, if you have particularly large customers, they may have in their contracts the right to approve if you're doing a sale of your business. So, make sure that you know what's in your customer contracts to see if their consent is required. There may be lenders and vendors that have approval rights for your agreements. You don't typically see them in a vendor contract, but depending on who the vendor is and the size of that agreement, sometimes they'll want to make sure that their customer doesn't sell their business to somebody that's not creditworthy or somebody they don't want to do business with. So be aware of those things. And lastly, if it's a business that has some minority owners, whether it's ex-employees or sort of other investors who may not be actively involved in the business, depending on the legal structure you use to set it up in the first place, there may be other people out there who are not involved day to day, but whose consent may be required if you're thinking about a sale. And the other point that I think sometimes people don't think about, sellers and buyers don't think about, um, in terms of what happens during the period between when you sign and when you're able to close, right? And that period could be immediate. You can have a sign and close depending on the type of business. Or if you need to get some of these third-party consents, that period could stretch on for months. If you need to get government consents, or if you need to get consents from some of these other third parties that I mentioned. So there's going to be a period of time where the buyer has signed an agreement to buy the business, but it hasn't closed yet. And the parties, having a sense of how long it'll take to get to close will inform what kind of provisions you have in the purchase agreement, where the parties can agree on, okay, the buyer has agreed to buy the business, but isn't in there yet because it hasn't closed. The buyer is going to want protections for how the business is operated during that period. And this is oftentimes a point of pretty heavy negotiations if the parties expect that the time between sign and close will be lengthy. And so it's important to, be aware that this is an issue and to get ahead of it and to spend the time that you need to address this in the deal documentation so that it doesn't become a fight, right? When the seller is running the business in the way that, he or she thinks it should be run, but the buyer doesn't agree. And that becomes a source of disputes, and that's what we don't want. The last bullet on this page, in terms of being careful not to gun jump, this is perhaps relevant in a smaller number of cases where if you have a deal that requires a government consent, the buyer doesn't may not be allowed legally to go in and make certain decisions for or even with the seller until that approval has been obtained. So again, this reemphasizes the importance of having, if you're the buyer, having your specialists lined up and on board early so that they can identify potential government consent issues so that you don't end up in a situation where you are making decisions for the company before the required government consents have come in. Remedies. So in this slide, a lot of times when people are working on a transaction, you only think about the upside, right? You're excited for there to be a deal if the parties agree on the basic business terms. They want to just rush ahead and think about all the great things that are going to happen when the deal closes. Right? You've agreed on a price, you've agreed on timing, you've agreed on the operating covenants, everything looks right, you've signed, let's go, let's get this closed. But the uh, some things that can get less attention than they should when you're working on the documents when everybody wants a deal are the provisions for what happens if things go wrong because people don't like to think about what happens when things go wrong. Um, the two categories of those kinds of provisions in a purchase and sale, broadly speaking, here I've labeled them, the indemnities, right? So if there is a problem after the deal closes, how are the parties going to handle the costs that are associated with those problems? And also termination provisions, right? If you sign a deal and then for any number of reasons, it doesn't end up closing, what happens, right? How does the document terminate? How does the deal unwind? So for the first point, um, and really the point I want to make here is that standard agreements, standard term asset purchase agreements or stock purchase agreements will have provisions for these issues. These are oftentimes thought of as boilerplate issues, and if go online, if you look in precedents of agreements, you'll see many different versions for term language on termination, language on indemnities, and the point I want to emphasize here is that there's boilerplate where you can look to see what other contracts have used, and you can more or less just adopt them for your deal. But these are the kinds of provisions that are in the back half of the contract, and people think of them as boilerplate, but it's very important to tailor them to the specifics of your transaction. And the reason for that is that if you have terms that are too vague or too generic, it becomes, it can, if you just sort of apply them because you don't want to think about the situation where things go wrong, and then if a dispute does come up, it can hurt, either or both parties because the language is too vague or it's not appropriate to the specifics of the deal. You want to be for these are the kinds of provisions where you want to make sure they're appropriate for your deal. So what do I mean by specific indemnities for the known risks? Right. So here, this goes back earlier to the importance of having diligence done correctly and done comprehensively. Is that if everybody does their job right, you will know as the buyer what the potential liabilities are in the seller's business. And if you know that beforehand, the parties can agree on the best way of allocating that risk, right? And there you can be you can be very precise here and specific of if this particular claim, if this former employee claim or if this tax liability comes up, here's how we're going to share the loss of that, right? And there are different ways you can slice this up, different ways you can divide who pays what, how much, and when. Depending on the size of the deal, a lot of times you're seeing, now more recently we've been seeing what are called reps and warranty insurance, right, which is basically having a third-party insurer come in and be in a position where if there is a liability that comes up after a deal closes, the insurer may be able to pay out the losses there to the buyer. Historically, that's been available for, very, very large deals, $100 million plus deals. But we're starting to see that for significantly smaller deals, in the sort of eight-figure deals where, there are underwriters, there are businesses out there that can provide insurance. So there are different ways of addressing indemnity risk that isn't just if a claim comes up, then it's either all or nothing, right? It's either the buyer bears all of the risk or the seller bears all of the risk. There are more fine-tuned ways of dealing with this. And so, thinking about that for the particulars of the risks in a deal is a way of can be a way of addressing those things and helping a deal that otherwise may have too many risks for the buyer to be willing to go forward to actually have those get signed and closed. And termination provisions, again, there are going to be a million contracts out there that have very generic language for how to deal with a termination, right? So if the party breaches, then the other side can terminate. And that may be appropriate for certain kinds of agreements, but for when you're buying or selling a business, you want to be much more precise and specific about what are the scenarios where the buyer may be able to terminate, what are the scenarios where the seller might want to be able to terminate. And you want to be specific about that so that you don't have a dispute, right? So that you don't actually have to go to court or threaten to go to court to resolve this issue. If there are situations that come up between when you sign and when you close, where it doesn't make sense for either party or for both parties to actually complete the transaction, you'll want to spell that out beforehand. And you want to spell that out beforehand, both so that the parties know what to do, and also so that you can agree on what, if anything, either party has to pay to the other as a termination fee for terminating the contract. And these are things that you can agree beforehand that will lower the costs and likelihood of a dispute later on. And this is not going to be something you'll find in what you think of as more boilerplate contract language for termination. Okay, last slide on this. So everything has gone right. You've gotten all the consents that you've needed. You've signed the agreement. You've gone out. You've gotten all the consents. The business has operated well during the interim, and you're approaching closing. That's great news. And there are just a few points that we want to highlight here for what happens at closing and after that you just want to be aware of, and that oftentimes what we've seen is people don't think about these. And it can come back to either create a liability or a risk, or just a headache, and things can be, you got to scramble at the last minute, and nobody wants to do that, or there's confusion about some point, and nobody wants that either. So the first point I want to make here is, again, and this again circles back to the diligence piece, is that you want to be realistic. Both parties want to have a realistic, not too optimistic, not too pessimistic target for when closing can happen, right? This is assuming that this is not a sign and close where everything can happen on the same day. If there's going to be a period between when you sign and when you close, for whatever reason, whether it's because there are consents, whether it's because the buyer needs to line up financing, for any number of reasons, if there's going to be a period of time, understanding what that is and importantly agreeing on what that is likely to be will be important for the buyer and the seller, because what you don't want to have is for the deal to take a lot longer than you anticipated, right? Because then everybody is kind of in this limbo position, and it's very stressful and nobody's happy about that. Conversely, you also don't want the deal to be ready to close a lot sooner than you expected. Because if you're the buyer, you may not have financing lined up, you may not have your transition and integration plan in place. And so being realistic about that on the front end is very important, and that may not be something that people are thinking about and agreeing on, and have that be reflected in the documents, right? So if you're the buyer and you want to make sure that you don't close too early, you'll want to have language in the agreement that says, that allows you to have a period of time when the last approval has been obtained before you're forced to close. And if you're the buyer, if you're the seller, you'll obviously want that to be tightened so that you don't want to give the buyer, too much wiggle room once everything has been satisfied and you're ready to close. And the last point I want to make here on items that people may not think about when they're working on a deal, because some of these are more technical. some of these are just not things you think about because they're not core to the major part of the deal, but that can create disputes or at least create headaches and complexities that you don't want to have to deal with. Um, just tick through these very quickly. If think through the pricing mechanisms for if for how to adjust if any adjustment is needed for the purchase price, because you'll have a period between sign and close, and there are standard ways of handling these. But you just want to be sure that these are in the documentation you have and that you understand how they work. Similarly with escrow releases, right? This has to do with some of the potential liabilities that we may discover during due diligence, and you just want the parties to know, if there's going to be a holdback amount, so that the buyer can be protected if there's a liability. When those held back amounts are released, what are the circumstances? What are the instructions? What are the triggers? Having all of those agreed upon will be very important. If the seller, if this is a founder company, if the seller is going to continue with the business for a period of time, there may be provisions for earnouts, right? So part of the purchase price may be contingent on the company post-closing meeting certain targets, and you'll want to be clear about what those targets are, who gets to make that decision, what are the terms for when the seller can get paid the last parts of the value of their business. You want to have those provisions, understood, and don't forget about them after the deal is closed. And lastly, if the founder isn't staying on with the business after closing, oftentimes what you'll see buyers insist on are some kinds of non-competes for the buyer, right? Because depending on the type of business, if it's mostly a human capital business, rather than buying a piece of IP or a factory or something like that. If you're the buyer, you may not want the seller to immediately after close go out and compete against you and diminish the value of the business that you just bought. And so this will be an important point for the buyer to make sure that they are protected for that the value of the business they've bought won't be undermined by the seller going out immediately and competing against them. And so this is something that'll be important to the buyer and will of course be important to the seller because it affects what you can do after the deal closes. Non-competes are an area of law where there's some variation, depending on which state you're in, depending on how you write it, and so you'll want to be careful to write the non-competes in a way that is, that makes sense for both sides from a business perspective, but also is written in a way that will make it enforceable in the way that both parties want it to be enforceable. So this is an area where people will want to make sure that they have the right advisors lined up so that they can have an agreement that they've spent all this time negotiating and then actually have it be enforceable. So that's the end of the materials that we wanted to cover. It's very much a lightning tour of a very broad set of issues. Again, we didn't go into the level of detail on the thought that for an audience that's not a legal audience, it's for business owners who are looking to sell or who are looking to buy. And the hope is that after all of this, that at least you'll have if you're watching this later on, an overview of, gee, these are the things that people often make a mistake in not thinking through or not identifying because they're not core to the main business points of buying and selling, and just to be aware of them and to get out ahead of them. Make sure that you have the appropriate advisors lined up who can assist on solving some of these. The issues that I've identified here all have solutions, and in many cases, if the transaction makes sense from a business perspective, the legal issues can be solved. And it's just a matter of doing that earlier rather than later so that it doesn't turn into disputes, it doesn't slow down the deal, and it doesn't give people headaches that are entirely avoidable. So with that, if there are folks who are here who have questions, happy to address them.
Yes, hi, my name is Penny, and I just had a quick question. If we've gone through the route of looking at selling outright, and we're now thinking that we might do a slow sale to our employees, are there any specific complications that you can kind of shed a light on in that case if we were turning it over to like our COO over a period of time?
Um, Hi, Penny. Thanks for the question. So, you actually see that that's a pretty common way of selling to existing management or existing employees. Um, when you say, slow sale over time, um, I guess, is that just it sort of I guess it depends on the issues that can come up depend on, what you're trying to solve for, right? If it's sort of the longer there is a period when you transfer ownership, it's like some of the issues I talked about earlier, but in terms of what are the agreements between buyer and seller during the interim. What happens if there is something unexpected, either to the business in particular or to the industry, or to the broader industry. Those are unknowns, right? Between when the ownership and financial benefit and risks, uh, who owns those benefits and risks, the current owners and the future owners. The longer that period in between when the transfer happens, the more uncertainty there is. And so the more important it is to figure out how those risks are allocated. If we're talking about, 3 months, that's one thing. If we're talking about a year or even more, then it becomes then the uncertainties become pretty significant, and you'll want to, if you can, um, avoid having a period of uncertainty and not knowing who's responsible for figuring it out. So that can be complicated if you're talking about a period, between when everyone's agreed, here's who's gonna own the business in the future, and then actually having that transfer. Again, there may be ways of handling it, but the extra time does create more complexity.
Great. Thank you. We're trying to figure out how I get paid over the 5 years time period. And I'm trying to figure out whether it's partially giving them the business or selling it with the understanding that we would have a payout over a period of time to make it manageable.
Right. I mean, if it's mostly a financing issue, I mean, you can maybe the buyer just has to try to find a source of financing so that the current owners, aren't put in this position where they're still responsible for running the business, but may not be getting um the benefit of the value of the business until, a period far in the future or years in the future. And then if something goes wrong in the interim, the current owners are in a bad position, right? Because um, if the deal sort of falls apart in the interim because of some unforeseen sort of circumstance.
Perfect. Thank you very much, Henry, for that response.
Okay. I think barring any more questions from our current live audience, I just want to say thank you again to both Henry and Hillary for joining us. That absolutely fantastic presentation that you gave today, Henry. Again, as you stated earlier, if anybody watching this recording later has any questions, comments, concerns, I'm sure Tom would be happy to field any questions, or either Hillary or Henry over at HWG would as well. But again, thank you all so much for joining this brown bag presentation.